Do you think it should be a higher standard? I mean, if they call this the civil death penalty, if this is what our statutes call it, is a civil death penalty, should the standard be even higher than?
All you have to do is an adoption proceeding. So it's much simpler, and you don't have to go through that process of having any findings of fault or having that parent admit fault.
I want to be careful not to suggest that a parent can go before a court and say, I'm done, I'm out. And the court say, well, sir, thank you for your time. You are no longer father.
It was a really difficult process. And unfortunately, a lot of them did turn to termination of parental rights. And then once we got to that point, a lot of my clients would voluntarily relinquish their rights.
Hey everyone, welcome to today's panel. This is our Nevada Judges Termination of Parental Rights panel. My name is Alexis Brown. I do not practice in the areas of family law, so I am super excited to learn a lot today. I am an attorney in town, but don't practice in the area. I have my own practice in mostly tenant rights, landlord-tenant matters, mostly tenant rights. Today we've got Lance White, Monica Caffaratti, both from Reno, Nevada, and then we also have Emily McFarling, who is a certified family law specialist. So we'll go ahead with some introductions first. Lance, why don't you go ahead and tell us a little bit about yourself?
Thank you. I currently own a family law practice here in Reno with some lights. Before then, I was a court master for about 7 years. And before that, for about 4 years, I represented parents who had had their rights terminated, or rather were in the process to have those terminated.
Well, thank you so much for joining us today. Monica, tell us about yourself.
Thank you, Alexis. I'm Monica Caffaratti. I'm a sole practitioner and owner of MJ Caffaratti Law in Reno. I would say about 95% of my practice is family law. And I did begin my career at the public defender's office representing those whose children were taken away by social services, and which unfortunately turned into termination of parental rights. Saturday, sorry.
Welcome. And Emily, welcome to you as well. Please tell us about yourself.
I'm Emily McFarling. I'm the managing partner of McFarling Law Group in Las Vegas. It's an exclusively family law firm, and my practice is specifically focused on appeals of family law matters.
Great. Welcome, everyone. Thank you, everyone, for joining us today. We'll go ahead and get right on into it. First off, we'll go ahead and start with Monica. If you wouldn't mind just explaining a little bit about what termination of parental rights proceedings are and how they're different from your ordinary child custody case.
Sure. So ordinary child custody cases are hearings and cases to determine custodial rights, whether one parent will have them, whether they'll have it jointly, visitation. Termination of parental rights, on the other hand, is exactly what it sounds like, terminating parental rights. And it is a fundamental right to raise children. So it is a big deal. And the Nevada Supreme Court has said that it's tantamount to a civil death penalty. So it is more of a difficult process. Of course, you could have the state involved who get involved and try to terminate a parent's rights for their conduct. And then on the other side, you can have parents who want to either terminate the other parent's right or themselves, or work together and do it. So I would say in a nutshell, that's the difference.
So it sounds like there's a few different ways that these parental rights termination cases can get into the courts. Lance, can you tell us a little bit more about those different ways that they get into the court system?
Well, there's the public, I call them public or agency cases that usually follow a court making a determination that there's been abuse and neglect. Children have been removed from the home. Then the agency works with the parents to return the children. If that doesn't occur and they have grounds, and it goes on a termination process. There are also private termination of parental rights cases. Those tend to be a little bit different. They tend to be more along the lines of there's a new parent ready to step in instead of the other, and they tend to be move much quicker, whereas the agency TPR tracks can take quite a while. There are a lot of safety nets built in, and frankly, just the workload the court has ensures those aren't necessarily the quickest procedures.
And when you said the agency, you meant the Department of Family Services?
That's correct. That's correct. as represented by the district attorney's office.
What are there major differences between, other than just sort of the way they get into the court system? Are there any differences inside the court in those cases, or in the law related to those kinds of cases, whether they be brought by the Department of Family Services or by a parent or other person?
Well, the standards are the same. There, you have to demonstrate that there's parental fault, and you also have to demonstrate that there has been, or it's in the child's best interest to terminate the relationship, to terminate the parental bond. I will tell you, in practice, those two things really meld together. I don't see often where a judge would say something like, well, this child's going to have a horrible life because it's obvious it won't be in the child's best interest, but you know, the parent kind of squeaked it out. No, they will give you findings that are going to track the statute, but I think really they meld together more than you might think, but you have to, when you give a decision, you have to outline on both of those aspects.
Because parental fault is one factor and the child's best interest is the other factor. Is that what you said?
Correct. To a clear and convincing standard. Clear
and convincing evidence of both parental fault and then the child's best interest.
That's correct.
Emily, do you have any examples of that you might be able to give of where parental fault is found, or any interesting anecdotes you might be able to share about cases where parental rights have been terminated?
So in the DFS cases that are filed, obviously those ones have a very specific pattern where the case has gone through the system of a child being removed from the home, and if the parent doesn't do what they need to do to get their child back, or things are so extreme that there's not even an option of it. Eventually the case will wind its way to the point of having a termination of parental rights proceeding. I don't handle those cases as often as the ones filed by other parties, so the others might be able to comment more on those. But as far as ones filed by someone other than DFS, those often are filed by parents. Our statute allows for a termination of parental rights petition to be filed by anyone. So they're not necessarily filed by the other parent. They could be filed by a grandparent, a guardian, any other person. But the ones that I've handled most often have been filed by the other parent of the child. And in those situations, it's often just a situation where the parent hasn't been around and hasn't paid child support, hasn't had any contact with the child for an extended period of time. And generally, if there hasn't been a CPS case where the child was removed, in my experience here in Clark County, the judges are really hesitant to go in and terminate parental rights unless it's something pretty extreme, and unless there's some step parent or another person waiting in the wings to adopt. And so even though the statutes have the same standard, how they handle them is very, very different. If a case hasn't gone through the system, and if a case is being filed by a parent or a guardian, not by DFS, then there isn't that record of an abuse and neglect investigation having been done or things like that. So those are most often, that dad hasn't been around for 10 years, 5 years, hasn't paid child support. There's a stepdad waiting in the wings, and we'd like to get some stability for this child.
So it sounds as though then in those cases where a parent or a guardian or someone files these petitions, maybe the court focuses more in those cases on the child's best interest because the pattern of neglect or anything maybe doesn't exist as in the DFS cases. Is that right?
Yes, or if there is abuse or neglect, there isn't necessarily such a strong record leading up to the termination of parental rights proceedings, or the neglect may be just having been absent, having abandoned the child.
Sure. And on the abandonment aspect, is there ever a time when a court might assume abandonment, that a parent has abandoned a child?
I guess maybe if a parent hasn't been around, I don't think they're going to assume it. You know, someone's going to have to present evidence of an extensive amount of time that a parent hasn't been present in a child's life for that.
So would there, I guess I'm wondering if there would ever be a point, I guess, when the court would presume it, but it sounds like maybe not. Or can anyone else speak to that, Lance or Monica?
Sure. When a parent has left their child in the care of another, or they can't be found, it is presumed within 6 months that it is in the child's best interest for the rights to be terminated. Now, once the parents are located, I believe they have 3 months to come forward within that time frame. But, you know, as Emily said, of course, evidence has to be presented to prove that, but there is a presumption that it would be in the children's best interest to have those rights terminated.
And you said that that's if they've been left with someone, basically abandoned with someone for more than 6 months.
Correct.
Got it.
And I believe also if a parent has had a termination of parental rights as to a sibling, it's presumed too. And that it's rebuttable, but you know, the parents, a lot of times I found especially when I was at the public defender's office, they're obviously not in a good state when their children are removed. And although the state is required to provide them reunification efforts, they just get discouraged and it's not enough. There's not enough of those life skills. And so I personally think that presumption with a sibling, you know, because I don't think there's any time frame on that, I don't know. I just am hesitant about that.
Interesting. So so you said if a parent, or I'm sorry, a sibling has already been abandoned or has been sort of
not necessarily
terminated.
abandoned.
Oh, sorry.
Correct.
Okay, so
Yeah.
just the parental rights, if they've been terminated for any reason, really, then
For the parental fault, and it's in that child's best interest. Correct. So just the termination itself. Yeah. I'm sorry, I didn't mean to interrupt you.
You're okay. No, that's interesting. This is all very interesting for me to learn. And I hope that our viewers are also learning quite a lot from it. You had mentioned that a parent can actually, someone had mentioned a parent can terminate their own rights. Lance, do you want to explain more about that? Can a parent, I guess, terminate their own parental rights?
Well, I want to be careful not to suggest that a parent can go before a court and say, I'm done, I'm out. And the court say, well, sir, thank you for your time. You are no longer father. They can't do it in that manner. What they can do is they can initiate a petition and they can present evidence that it would be in the child's best interest. And also that there is fault in regards to them. So it's obviously possible. It's not convenient like you might think when you say terminate your own rights. And certainly the court will weigh the evidence. It has to make the same determinations. You just can't go in and ask that you no longer be father or mother.
So
I say that not to be rude, but typically when someone's trying to terminate, and the other lawyers will not, when someone's trying to terminate their own rights, it's always the same fact situation. I owe somebody $8,000 million in child support. Fine, I'm gonna terminate my rights. Well, it's often not enough.
would also, even if you were to terminate your parental rights, would you still have child support obligations from before you terminate?
Yes, but like anything, that can be negotiated away. Like, for example, if someone really wanted to end the parental rights of the father, they might say, well, in lieu of going to court, if I would agree to waive support arrears, would you be willing to sign? Because I have somebody that wants to adopt this child. So there's some horse trading there often. And when I was a public defender, I would often tell the men that I represent that, look, this is something you can ask for. It doesn't look like you're going to win anyway. So let's try to negotiate something that won't leave you in debt. And of course, sadly, that had a lot more pull than you might think.
That is unfortunate that when, that people have to make those decisions, very difficult decisions based on, sort of an amount of child support. So Emily, do you have anything to add about parents terminating their own parental rights?
Yeah, there's a specific case on it in TMC. It's a 2002 case where a dad had filed to terminate his own parental rights, and it was denied. And that was affirmed on appeal that it's not, as Lance said, you can't just walk into court and say, hey, I want out. It's not something that really happens. You know, I actually did have one that I filed probably 15 years ago or something like that. I was the petitioner asking to terminate my own client's rights because for some reason we had agreed upon it. For some reason, the other side was like, no, you have to file it. And the court did grant that, but that's the only time I've seen it. It's something that certainly the court would look at with suspicion when someone's going in and filing to terminate their own parental rights. In practice, if you have an agreement between the two parents to agree to terminate the parental rights of one of them, you know, it's probably best to have the other parent file and be the petitioner, the one who's not terminating their parental rights, just because it isn't a given that the person terminating their rights can ask for it.
Can I add to that? Oh, I'm sorry.
No, of course,
add
please.
to that is that when parents do agree that one parent's right should be terminated, and often, as Lance said, there's someone there to adopt the child. If the child's 14 or older, you have to have the child's consent as well. So I just thought I would throw that out there, give a little bit more information to our viewers.
I was curious about when parents agree, you know, if there is an agreement in place between two parents, you know, how are the judges scrutinizing those even still, making sure that all the factors are in play, or how does that work? Monica, maybe you want to comment on that.
You know, the ones I've done, there's been someone there to adopt, and so they've gone, you know, pretty smoothly. Since my days at the public defender's office, I haven't had to really deal with either trying to terminate someone's rights or defending someone against that. So maybe one of the other panelists might be better to answer that, but in my experience, it's been actually quite easy.
Sure. Lance, do you have anything to add to that?
I have done some private termination cases, but I've never had an agreement. And I assume that up here, the judges are excellent. I'm sure they are everywhere in the state. And they'd still have to make the same findings, whether there was an agreement or not.
I've done quite a few of agreed upon termination parental rights. That's probably the situation that I most come across them in my practice. And here in Clark County, the judges do not like termination of parental rights. So even with an agreement, you know, they're going to scrutinize it and look at what's going on. There's been, you know, there are some judges that really want to have a step parent waiting in the wings to adopt. And so that's a criteria that they, you know, has been kind of informally put in place here in Clark County as something that they look at. But if you have a step parent waiting to adopt, you don't have to have a termination of parental rights proceeding if you have consent. So if you get the consent of the parent who's giving up their rights, you get a consent for them to relinquish their rights to the step parent. All you have to do is an adoption proceeding. So it's much simpler, and you don't have to go through that process of having any findings of fault or having that parent admit fault, because if they're consenting to terminate their rights, they're actually having to admit fault. Whereas if they're consenting to relinquish for an adoption, there's no fault element that they have to admit to or that the court has to look at.
That sounds like a much better option for anyone who has that situation, because making an admission of fault in a court record would certainly be a different thing than just agreeing to basically say this person is taking over the parental rights. Is that kind of the difference between saying, yes, I'm at fault for doing something that's maybe not in the child's best interest versus a relinquishment is just saying I'm handing it over voluntarily? Exactly. Is that right? Got it. That's so interesting. So another question for you. So when can a parent who is involved in a termination of parental rights proceedings get a court-appointed attorney? This might be a good question for Lance and Monica. They worked in the PD's office. So Lance, why don't you go ahead and start that one? How do you get a court-appointed attorney if you're involved in these proceedings?
Initially ask. Both counties have, well, the statewide has a procedure to give public defenders to folks that have had their children removed that are then going to go through a termination parental rights trial. Thus far, it's been pretty much automatic, though case law says the state doesn't necessarily have to do so.
There's case law that says you don't have to, you're not guaranteed court-appointed counsel in a case like this.
Right, and the case is they really tried to walk a fine line something to the effect of, well, if it's a complex case, certainly they should be, but in most cases, there's no absolute right. However, we encourage the state to continue to appoint. Well, what have I said? I've said if it ever comes down to budget cuts and you want to make sure, to spend your dollars correctly, the court's not going to make you appoint one of these cases, essentially. So for all intents and purposes, these parents are given attorneys if they can't afford one on their own. They don't have an opportunity to attorney shop, and I'm sure Monica had this. You can't fire your public defender, then come back, I want another one. You get one bite at the apple, and that's how that usually goes. It's not required because of that case, but effectively it's done for everyone.
Can you represent yourself in these proceedings? Not that I would ever advise anyone to represent themselves in a proceeding like this, but Monica, can you go pro se in a termination case?
Sure, you can go pro se in any case. But Nevada does offer the opportunity to have an attorney appointed. And I would, if you find yourself in a situation where the state has removed your children and you qualify, I would suggest getting an attorney.
Absolutely. Agreed.
The statute on appointing an attorney, it's our NRS 128-100. It actually looks at if a parent desires to be represented by counsel. And so some of the judges here in Clark County have interpreted that to mean that if they ask for one, and then if they're indigent, right? So if they're indigent and they ask, then the judges are cautious and make sure that they appoint someone. And this is not in the DFS proceedings, and there I think they do, but in the private proceedings, they really look at whether or not someone asked for one, and then they get into an indigent analysis to see if they can't afford one on their own.
Definitely need to make sure if you need one, ask for a lawyer in these kinds of cases. Absolutely. When can a person who has had parental rights terminated get them restored? Maybe Lance, you want to take first crack at that?
Well, to tell you the truth, I was unaware of this update. I know Judge Hardcastle formally introduced it. It didn't get passed, but now you have that opportunity. If your rights have been terminated, the child has not been adopted, and you initiate a hearing, and then you have an opportunity to state your case. Judge makes a finding, and the rights can be restored. However, just from a practical standpoint, a little bit like the adoption workaround, when I was a court master, I heard juvenile guardianships. I had a guy that had his rights terminated, came in and asked for a permanent juvenile guardianship. Under the guardianship statutes, he had turned his life around. He was a great guardian, everyone agreed. So that was a much quicker process, but for other reasons, the restoration of your parental rights is important. So it is possible now. And I was actually surprised. It hadn't gotten a lot of traction for a while, but it's on the books now. And so I don't know, Emily or Monica, have you heard of anybody actually petitioning, getting them back, or is that just kind of a dead statute out there?
I don't have a lot of experience in that area, and I haven't really had many people come see me and request, a consult on that. So I will defer to Emily.
I haven't come across it at all yet. NRS 128-170 is the statute that governs restoring parental rights, but it requires that the child or the custodian of the child be the petitioner in it, and that the parent consent to it. So it's not necessarily a situation where the former parent comes in and says, I want my rights back, but the child would come in and say, I want my parent back. I want the rights restored of my parent. But I haven't actually had anyone come in asking for that in my practice ever.
That's interesting, but it does sound like, in some cases, for instance, the DFS cases, there are reunification requirements or attempts at reunification have to be made, right? Monica, why don't you, explain maybe a little bit about that.
Well, the DFS has the obligation to try to reunify and give the parents the opportunity and help the parents fix what the problem was, essentially. And I found when I was at the public defender's office, a lot of times when it moved to termination of parental rights, it was due to token efforts. They say that the parents didn't really, try that hard. which was kind of hard because we're working with people that don't have a lot of life skills anyways. And to say that, you have a limited amount of time to change your life around. And, oh, by the way, you have this added stress that we're going to hold on to your kids until you do so. And you can see them here and there supervised. It was a really difficult process. And unfortunately, a lot of them did turn to termination of parental rights. And then once we got to that point, a lot of my clients would voluntarily relinquish their rights because they had the opportunity to maintain some kind of contact, receiving cards, pictures of like birthdays and things like that. So,
and then it sounds like even though there is a law that allows a parent to come back and petition the court, well, I guess no, it has to be the child or the new custodian, apologies, has to come and petition the court. It is a possibility if you apparently have agreement of either the child or the new custodian to come back and maybe restore those rights if the life has, if you change your life around, that kind of thing. But it doesn't sound like in practicality it really happens around the board. Not at all. But Lance, you mentioned you had an instance where someone had terminated or had their rights terminated, but was able to become a guardian, sort of a little bit of an end run around. Is that what you said?
Yeah, and it was, at first I was extremely hesitant, as you might imagine, to grant a guardianship to someone who had been judged by a court, not to be able to retain their parental rights. But this individual had turned their life entirely around. They were excellent. The child at that time was 14. They were in agreement. It was a great fit. And so, yes, it raised a presumption that because of this TPR, that maybe this isn't the best guardian, but the family was in support. And so that's how that individual did it. And that he did that on his own, just filling out some paperwork at the self-help center.
Oh, wow.
Hey, Lance, can I ask you, how long was it till the parent came back and asked for guardianship? How long did it take him to turn around his life?
Well, it took about 5 years, but they had contact. Just because there's a termination, everyone thinks, well, I'm never going to see my child again. Especially in the rural areas, you might see that child every day. And
Right.
so one of those situations where, yes, we had a TPR, your rights are terminated, but I'll pick Billy up tomorrow at 8 like I always do. It's not a protection order. I mean, some people need that, and so it's one of those cases. And so I think there's a reality for a lot of these termination cases where they keep contact with the children, especially in the internet age. It's not a baby in a crib and you never see one or the other again. They keep contact.
And because really the terminating the parental rights is sort of terminating the legal right to be the parent of the child, which means taking them to, can't make medical decisions, you can't make school decisions, you can't do any of the things that a parent does legally with their child, right? That's really what's happening. You could maybe access the child if the other parent agrees or whoever the custodian is agrees, but you just can't make the decisions and do the things legally that a normal parent would do, right?
Correct.
That makes sense. So we've got some more questions. I understand there was a recent opinion that prohibits hearing masters from handling these trials on termination of parental rights. Do any of you have any insight to share about how about this decision and then the impact that it might have? So Emily, do you maybe want to discuss the decision?
This is probably a better question for the ones that do the hearing master type.
All right. Well, Lance, you mentioned you were a hearing master. So how do you, what about this decision from your perspective?
All right. Well, first of all, the decision was 4-3 with the chief in the dissent. And I have found that how you value masters is how you even decipher these cases in regards to them. And I believe that actually this was more of a, often you know this, when a court issues an order, sometimes the order is more to do other work than it is that decision. And there's been a lot of conflict about how to use masters. Unfortunately, we're defaulting to senior judges on everything lately. But so there's been this kind of back and forth. And so I saw this when I read it as a very blatant opportunity on part of the court, not nefarious, courts do it all the time, to say, hey, we want this to be like this. And so they reached down and found issues that weren't raised on the appellate level. And the dissent actually does a really good job of pointing that out. And so as a former public defender of these parents, it actually takes away it lowers their due process rights. Because a master that's hearing a trial in these sorts of cases tend to be very well qualified, whereas at the district court level, you might have a senior judge who hasn't been elected to the bench in 15 years. But somehow that gives the protection that the master, whose decision can be objected to, they can request an entirely new trial. Somehow having the senior judge is a higher level. It's not. It's just this sounds like a housekeeping matter, and they use this case to do it.
Interesting. Monica, what is your take on the decision?
Well, unfortunately, I haven't looked into it thoroughly. I just didn't have time, but I will. I'm very interested given Lance's take on it, and I will definitely read more into that.
Well, I find it interesting. So the process, it sounds like, and we can maybe explain for the viewers, the process, it sounds you could go to a hearing master, and then the hearing master's ruling could be objected to. But now it sounds like as though the hearing master has been sort of taken out of the equation and you have to go straight to a judge.
That's correct.
Interesting. And so I could see where, I mean, and Emily, I mean, I imagine you might be able to see too, where that does take out maybe an element, right, of the steps, and due process requires as many steps as possible before we get to a final decision in some cases, right? So, I mean, if in your cases, do you see hearing masters being used or not? I mean, I don't know if their hearing masters are used in any other cases of any other types in the family courts. But if they are taking hearing masters out of the equation, do you think that will affect any other kinds of cases?
It might. So there are certain types of cases that go to hearing masters, and the Child Protective Services DFS cases. There's certain types of hearings that are heard by hearing masters already. And here in Clark County, it used to be that they would hear almost everything. And we had one judge that was overseeing a bunch, maybe 3 or 6 hearing masters who were pretty much doing all of the proceedings. I don't know how long ago, maybe 5 years ago, or at some point, they switched it and expanded the number of judges overseeing the abuse and neglect cases here in Clark County. And just recently with this last election, they expanded it even more. And it probably has to do with, the concepts in this LLS decision, the one that says that these TPR trials have to be heard by a judge. I mean, one of the problems you have is that hearing masters aren't elected, they're employees of the court. So they haven't been vetted by the voting public to the same extent that a judge has, that they're looking at due process rights. And even though you can go in and challenge the decision of a hearing master and have it go up and be heard by a judge, there's a standard that has to be met to do that. So it's an additional layer of, somebody looking at the decision, the judge doesn't look at the decision in their own, just from the beginning. They look at it with a deference to the decision that was made by the hearing master. So, given that termination of parental rights is such an extreme thing to do, in our case law in Nevada, it's referred to as the civil death penalty. And it's really looked at as this thing that you don't do absent extreme circumstances, having a due process protection that a judge has to be the one making that decision. It makes sense.
But I guess that brings maybe begs some questions about, are hearing masters, should they stick around? I mean, I guess that's the question this maybe decision sort of brings up all over the place. But a question that came up a little bit, but the clear and convincing evidence standard was sort of discussed briefly. What does that involve, and like how much more? What are the other standards, and why is this one so important in the termination cases? Maybe Monica, if you want to touch base on the clear and convincing standards.
Sure. So under the clear and convincing standard, it is just like it sounds. It has to be clear to the judge and convince the judge that the burden has been met. It's lower than beyond a reasonable doubt, like in a criminal case, but it's higher than a preponderance, which is more likely than not. So it is a higher burden, but
Lance, I guess this is a question. Do you think it should be a higher standard? I mean, if they call this the civil death penalty, if this is what our statutes call it, as a civil death penalty, should the standard be even higher than clear and convincing? What do you think about that, Lance?
Well, that was a dicta line that everyone uses before they take away parents' rights. And I'm being a little flip when I say that, okay? You don't have a right to a jury trial. You don't necessarily have a right to a lawyer if funds run out. And so using that dicta to insinuate any more than that's important is probably inappropriate, and we've all done it. So at the time of a TPR, if you get to a TPR trial through the public sphere, if you've had your children removed, if you've had an agency working with you, for all intents and purposes, your cake is already baked. And so there's going to be a history of the agency working with you. There's going to be a history of you at fault, you failing to do something. There's going to be a history of the child being better served by not having you as a parent. So it doesn't come up for the first time in a TPR hearing. And that's ironic about the court masters, to go back to this, is the court masters, I don't say at the lower level, but that make that initial determination to remove the children, that's the cake baked. And so to say, well, we don't want them on the tail end, but that initial decision, which is so important to whether or not this child will actually come back, well, that's fine. So I find that interesting. But going on, at the TPR level, there is not a lack of evidence to terminate rights. There is a plethora of evidence. And so they are difficult cases, but there isn't a lack of evidence for a judge to make a finding that supports that evidence.
So I think you mentioned that even though hearing masters are not doing the trials of these termination cases, they are still making the initial removal decisions. Is that right?
Certainly. And those are always subject to a judge countersigning, and they're always subject to an objection on the part of the client. And in this last case we referred to, the irony is it was brought by a mother who lost her parental rights. And this case will end up, I think, actually for parents in similar situations, having less due process rights because of it. And again, I think this case was designed to do some heavy lifting in other areas.
It's the time will tell. This is a really recent opinion from just this year, so I'm sure that its impacts will be sort of fettered out in the next years, right? I really appreciate your guys' time today. I have learned an incredible amount about these termination cases and who can bring them and why they can bring them and those kinds of things. And so I really appreciate all of your time. And thank you to our Nevada judges, Alex Falcone of our Nevada judges, for letting me moderate the panel today. And we will go ahead and be signing off and wish everyone a wonderful day and weekend.
Thank you.
Thank you.